Good afternoon, everyone. I hope the discussions and lectures so far have been to your liking. Thank you for attending this panel on white-collar crimes. I am today's moderator, Bruno Bodart. I'm an LLM candidate here at Harvard Law School and a judge in Rio de Janeiro, Brazil. My goal here is to better understand contemporary issues regarding white-collar crimes through a creative discussion with some of the highest regarded professionals in this field from the world over. I want to touch upon not only the internal legal frameworks in Brazil and the US for preventing and repressing these sort of crimes, but also the efforts to stymie these illegal transnational practices. We'll begin the panel by asking one of our three speakers to answer a question in the allotted time, around 5 minutes. I won't be strict with this time. And then move on to see what the other panelists have to say. But we also have some specific questions to some panelists in particular. And as the panel comes to a close, we'll be taking 10 to 15 minutes to answer questions from the audience. You may post your questions at any time by going to slide.do and entering the keyword Harvard Law Brazil. While we may not be able to take all of the questions, we'll get through as many as possible. I'll just introduce briefly the panelists. Judge Moro is a federal judge in Brazil. He oversees the car wash operation in Curitiba, Paraná. He's also a former professor of criminal procedure at the Federal University of Paraná. Mrs. Nancy Kestenbaum is a leading practitioner at Covington and also a former federal prosecutor here in the US. And Mrs. Neha, she spearheads a group of anti-corruption at the United Nations and is also holds an LLM here from Harvard Law School. So the first question I want to ask has to do with political corruption and the quid pro quo requirement. Both in Brazil and the United States, there's a murky line between, on the one hand, what is illegal, and on the other hand, commonplace, although immoral politics. Big corporations donate large amounts of money, hoping that the investment will pay off after the election in the form of tax exemptions, regulations narrowly suited to their needs, or government contracts. Interestingly, the Supreme Courts of both countries were faced with the question of whether the showing of a quid pro quo or this for that agreement is necessary to pursue a conviction for white-collar crimes. In McDonald, in 2016, the Supreme Court of the United States, in a unanimous decision, decided that the federal bribery statute requires a specific and focused official act by the public official in exchange for the payment or benefit. The Brazilian Supreme Court has adopted a rather weaker standard in the big monthly allowance case, the mensalão case, conceding that an indirect connection between the official act and the kickback is sufficient. So, Judge Moro, which Supreme Court has done the best in your opinion?
Tough question. I'll ask to speak on the pulpit.
Please,
for a moment.
Feel free to use the pulpit.
Well, good afternoon for all. I ask the permission for the organization before starting answer the question. Just to make a few statements about what is happening in Brazil. For a lot of people here, probably it will seem unnecessary, maybe absolutely unnecessary, But I think it's important to say some things, because in certain way, the world is paying attention what is happening in Brazil. Let me say this loud and clear, that democracy is not at risk in Brazil. Absolutely not. What is happening in Brazil is just the struggle for the rule of law, and I think the exactly opposite is true. At the end, we'll have a stronger rule of law and a stronger democracy, and even a stronger economy in Brazil. Another thing that I want to say is that there's two ways to look to Brazil now. In certain way, what is being revealed by this investigation, not only in my court, but in other courts, is shameful. Widespread corruption, I use the expression system corruption. These facts are very shameful, and they reveal certain failures of our democratic government. But there is another way to look at Brazil now, and I think this is the right way to look to the picture. Brazilian authorities and Brazilian people are doing their best to enforce the law against widespread corruption, and fighting impunity give us the hope that in the end we will have less corruption in Brazil. So in this other way, I think there is some reason to be proud. Not the judge, not the prosecutor, not the police officer, but Brazilian people as a whole. We must never forget that since 2015, millions of Brazilians went to the street protesting. Of course, they have a lot of flags, but one common flag was to protest against corruption and to give the support for not only the Lava Jato operation, but the enforcement of the law against corruption. And I would like to quote a former Harvard student who, after that, became one of the most prominent presidents of the United States. And this man, he gave a strong speech against corruption in 1903 before the United States Congress. And I think in his strong words, he resumed what we should think about Brazilian moment at this moment. Quoting, "The exposure and punishment of public corruption is an honor to a nation, not a disgrace. The shame lies in toleration, not in correction. No city or state, still less the nation, can be injured by the enforcement of law." These were the words of President Theodore Roosevelt in his third annual message in 1903 before the United States Congress. And I think this resumes the feeling of the most part of Brazilian people at this moment. Sorry for these initial remarks. And now I'll answer the specific question, and I will return to my seat there. Thank you. Well, this is a great question, and I think we need to make a distinction between petty corruption and grand corruption. Usually in cases involving paid corruption, you could find easily a quid pro quo agreement. For example, a guard, traffic official, who decides by receiving bribes to turn a blind eye for traffic infraction. It's not difficult to understand this quid pro quo agreement. But when you speak about grand corruption, sometimes it's a little bit different, because the public official sometimes he has a lot of public powers, and he could act in different manners, for example, to promote a private gain. In this Lava Jato case, and I'm speaking here only about the cases already tried. There are about 33 sentences already delivered by my court. It's interesting to note that we have some cases that you could identify easily the this for that agreement. For example, an executive of Petrobras giving a specific benefit to one of Petrobras suppliers, agreeing, for example, with additional costs to a public contract of Petrobras. In other cases, even with defendants who confessed, when you ask them, why did you pay the bribes, or why did you receive the bribes for the executive of Petrobras, and sometimes they answer that it was the rule of the game. What you get in exchange, and sometimes you don't have a specific answer. Some of these criminals, even ones that confess, sometimes they did not confess all the truth, but sometimes they did so, and sometimes they gave us this strange answer. I paid because it was the rule of the game, to keep a good relation with the executive of Petrobras. So sometimes I think in grand corruption or in system corruption schemes, not necessarily you will find an specific exchange, this for that. Sometimes this is dealt in a more general way. I like one example. I think everybody saw that movie, The Godfather, Poderoso Chefão in Portuguese. And in the first scene, you have Don Corleone receiving a man, Bonacera, and Bonacera is asking the Godfather a favor, a very bad one, because he had his daughter beaten by her boyfriend and a friend, and Bonacera went there to request help from Godfather, so Godfather would send men to beat the both persons. And after some drama, the Godfather agreed to help, not killing the men, how the Bonacera wanted, but sending men to beat these men. And Bonacera asked in the end of the scene what the Godfather want in exchange. And he say, I'll do everything that you asked to me. And the Godfather gave a very interesting answer. He says, well, I don't want anything now, but one day, maybe one day, I'll ask you something, and then I will need your help. You return the favor. I think that sometimes in cases involving gun corruption or system corruption, there is this kind of agreement, not an exchange for a specific official act at this moment, but maybe something that could appear only in the future. I find a case in the precedents of the federal courts in United States. I met last year here in Boston a fantastic federal judge, Mark Wolf, and he called my attention for these precedents. And there is one very interesting here involving it's United States versus Masi, a case of the First Circuit 2013. And there is a part of it, now I'm quoting, about this, about the quid pro quo requirement. It's sufficient if the public official understood that he or she was expected to exercise some influence on the payer's behalf as opportunities arose. I think it's very interesting precedent. In Brazil, and going to them, it's a complex question, difficult to answer in a few minutes. In Brazil, I think this is still an open question to our, at least our Supreme Court, and maybe the others superior courts in Brazil. We have this old case, criminal case 307, Ação Penal 307, a case tried by our Supreme Court in 1994, when the former President Collor was acquitted from charges of bribery. And at that time, it seems that the Supreme Court understood that it was necessary to prove a specific quid pro quo agreement. It's a very controversial case. But in the criminal case 407, Ação Penal 470, the mensalão case, it seems to me it's a more recently case, 2012. It seems to me that the court ruled at that time that it was not necessary to prove a specific official act, but this could be understood in a more general way. And allowed me to quote here, but the text in Portuguese that is in the ruling of the Brazilian Supreme Court. Para a formação de base aliada ao governo federal na Câmara dos Deputados, para ser mais preciso, também consta a comprovação de amplo esquema de distribuição de dinheiro a parlamentares, os quais, em troca, ofereceram seu apoio de correligionários aos projetos de interesse do governo federal na Câmara dos Deputados. In other words, the Supreme Court talked about official acts, but with some level of indeterminação, not specific official acts, but with some general level of these acts. So I think this is still an open question, but I think to deal with this problem, we have to understand that in grand corruption or in systemic corruption schemes, sometimes you don't have a specific official act that is trade for bribes, for example.
Thank you, Judge Moro. Mrs. Kestenbaum, what do you think would be a compromise between the strict requirement of proving quid pro quo and a broad criminalization of politics?
So first, a few preliminaries. As Judge Bodart said, I used to be a federal prosecutor here in the United States, but I no longer work for the government, so any views that I express are not those of our government. And although I do work for Covington and Burling, my views here today are not those of my law firm or its clients. They're just my own personal views. So Judge Moro spoke so eloquently about how the cases and investigations that are going on in Brazil today and over the past few years do not mean that democracy is at risk in Brazil. And although some people in this country have started to think that democracy may be at risk, it is not because of the Supreme Court's decision in McDonnell that contributed to that. The Supreme Court made very clear in the McDonnell case. Sure, now can you hear me better? Supreme Court made very clear in the McDonnell case that when Congress draws a line or a legislature draws a line about what is or is not bribery, then that line has to be very, very clear. Politics is not a pretty business. I think the word that Judge Bodart uses, immoral. I don't know if I would say immoral, but it's definitely not a pretty business, even when it's conducted lawfully. In McDonnell, Governor McDonnell and his wife accepted about $175,000 in payments, in loans, in a Rolex watch, in payments for their daughter's wedding and dresses. And so there was very clear evidence of the quid, the this. And that's often the case when government investigates prosecution. They find evidence of the this that looks and smells very bad. But the hard part is then how can they tie the this to the that? And what the Supreme Court said in McDonnell is that under the federal bribery statute, the that has to be an official act taken by Governor McDonnell. And what Governor McDonnell did in that case, such as making phone calls and arranging meetings, were things that he did as part of his regular day job as governor of Virginia. And the Supreme Court said, therefore, the this and the that were not tied closely enough together. So in terms of your question about where should the line be, first of all, there are many laws out there, aside from bribery statutes, that make it improper often for public officials to accept things of value. So for example, there are often federal and state ethics laws that govern when public officials can personally benefit and take things of value. But that's different than an actual bribery statute, which again, you have to show a quid pro quo tying to this to the that. In terms of where I think a compromise should be, my own view would be that there should be a test. Well, first of all, as I said, a legislature needs to make very, very clear what is and what is not criminal, given that what public officials and politicians do day in and day out are things like arrange meetings, help constituents. And so if they're going to criminalize that conduct, it has to be a very clear line. I personally think that something like a but-for cause test, similar to the torts context, in other words, a public official took an action that he or she would not have taken but for the fact that they received or either something of value or an offer of something of value, would be along the lines of the right type of test.
Right. Mrs. Das, you work at the UN Global Compact, which is an anti-corruption department at the UN, which focuses on prevention and reform, such that incidents of corruption and white-collar crimes are stymied at their roots. What has your experience being while addressing corruption issues with a collaborative approach between the governments and the private sector, which traditionally accuse each other as the main perpetrators of corruption?
Thanks for the question. So before I answer, I just wanted to say that when I was studying here, the HLS Brazilian Association was a very vibrant and dynamic community. And it's so wonderful to see that the tradition has carried on over the years. And congratulations to all of you. The agenda looks promising, and coming 4 days, I'm sure all of us, including speakers and attendees, are going to learn a lot. So congratulations. And yes, so even before answering the question, a little bit context about my organization, because when Bruno invited me to speak at the panel, it was interesting to see that, we had a mix of the judiciary, the lawyers, the prosecution. What would I be contributing here? So UN Global Compact, and perhaps a lot of you may not know, is the only private sector initiative of the United Nations, and it focuses on corporate sustainability in 4 main areas: human rights, labor, environment, and anti-corruption. And so basically the idea is that we work with the private sector. Usually UN works with the governments, but we work with businesses to encourage them in advancing a principle-based approach to doing business and aligning their core operations to the 4 goals that I mentioned. So the anti-corruption principle is sort of the last but not the least principle, and it says businesses should work against corruption in all its forms, including extortion and bribery. Now, when the initiative started in 2004, around the same time, actually UN Global Compact existed since 2000, and the 10th principle, the principle against corruption, was added in 2004, around the time that UN Convention Against Corruption was adopted. There was a lot of controversy, you could say, because corruption is a sensitive issue. And as a UN entity with the mandate coming from the General Assembly, member states, governments, we're working with the private sector and then trying to have that difficult conversation about why does corruption actually happen, who's to blame, who's responsible. And as all of us know, it's a two-way street. It's a demand and supply where both the public officials and the private sector are equally responsible, and therefore the solution has to come from both. So private sector companies are part of the solution, not just part of the problem. So yes, it has been tough. So coming to your question, yes, it has been really tough to adopt that collaborative approach. In the beginning, it was just very difficult to get the regulators and the companies just to come inside one room. At some point, like one of our local chapters was giving that example that they literally had to lock the doors so that, people just don't have any option but to start talking with each other and sit across the table. And we adopted sort of a 3-pronged approach. So the first, especially when the initiative was just starting and there was a lot of hesitation to collaborate, the dialogue. So, that UN Convention Against Corruption, which is the, the main international treaty around anti-corruption and related topics, member states are its signatories, and Brazil is also ratified it since the beginning. And what we did was that, the implementation of the convention is reviewed every year, every alternate year. And at some point we said, well, let's just not get the regulators to talk about how the treaty is being implemented in various countries through national legislation. And so we involved the private sector in the review mechanism, where they actually came to the, the big conference of state parties, sat at a table and said that these are the gaps we see in the implementation. So for example, not adequate laws, and if there are laws, not adequate enforcement. So yes, dialogue is, the one prong of the approach. The second prong was basically collaboration. So, joint trainings, trying to identify the gaps and then addressing them through concrete projects, especially done locally. And just to take the Brazilian example, we have a very strong chapter in Brazil, which at this point is overtly active now because they have a, big responsibility to continue positively engaging companies in the midst of the issues. And as we say, every challenge is an opportunity. So despite the corruption scandal, which has involved so many companies that actually engage with us at the headquarters, our local network is working relentlessly to at least have the dialogue going, and not just kind of sit in different corners of the room and say it's a problem only the prosecution can solve, or penalization is the only way. So basically transformation of organizational behavior. And the third work is through collective action. So what we've seen is that collective voices always have more impact. And so when we work with the private sector, even if it's not the big multinationals whose voices are always heard, but small and medium enterprises or unorganized sector, we ask them to come together. And World Bank, and those of you who are interested, has developed this very interesting model of collective action, where there are 4 different kinds of collective action. And Transparency International, is a leading civil society on anti-corruption issues, has also promulgated this model of integrity pacts. So basically, we ask the private sector, there's been inclination that we'll put our house in order, we'll work with our peers, we'll work with our, rivals, and let's say if we are bidding for a procurement contract, companies in one sector sign an integrity pact that regardless of the laws, regardless of the enforcement, regardless of what the government wants, voluntarily, we will not pay bribes. Now, that sounds like a very utopic, idealistic situation, but there are numerous instances where integrity pacts in procurement processes have voluntarily been adopted, and now they are forming part of laws because of this whole policy advocacy. So in India, procurement laws contain mandatory integrity pacts, which doesn't mean that corruption has gone away, but it means that there's a first step forward, that policy is influencing laws, and our work in getting those, the thought leadership together and getting the various sectors together and adopting a partnership process has, or at least has the potential to lead to transformation and reforms. Yeah.
Thank you. Now I think we can talk about the topic of prison pending appeal, which is one of the most debated questions of criminal procedure in Brazil today. Whether defendants generally remain free pending appeal. A peculiarity of the Brazilian system is that common criminal cases may even reach the Supreme Court on appeal from a state or from a federal appeals court. There's a provision in the Constitution stating that nobody can be considered guilty until their appeals have been exhausted. Some people interpret considered guilty as meaning detained, which would result in delaying the enforcement of prison sentences against white-collar criminals for many years during their appeals. Mrs. Kestenbaum, can you explain to us in a nutshell the main features of the American system with regard to imprisonment while the appeal is pending?
Sure. It sounds like we have very different systems. So I'm going to describe how it works in the federal system. Obviously, we have our federal system and then states and localities, but the features are generally the same. So our Constitution, the 8th Amendment, prohibits excessive bail. And that means before conviction, either by trial or by guilty plea, we generally have a presumption that people will be released on some type of bail and not detained unless the government can show that either they're a high degree of flight risk, they're not going to show up to the court proceedings, or that they pose a danger to the community. But once a defendant has been convicted, either by trial or by guilty plea, then that presumption is flipped. And especially once a defendant has been sentenced, then the presumption is that if they have been sentenced to a term of imprisonment, that they will begin serving that term of imprisonment unless the defendant can show by clear and convincing evidence, which is a high legal standard, that first of all, they're not likely to flee or pose a danger to society, and that their appeal is not just for purpose of delay, and that their appeal raises a substantial question of law or fact likely to result in reversal of their conviction or a new trial or a sentence that doesn't include a term of imprisonment. And so if that's a very hard standard to meet. Individual defendants can appeal either to the sentencing judge, the trial court level judge, to say that they've met that standard, or to the appellate court to say that they've met that standard, or if their appeal has been decided and they're seeking a writ of certiorari from the Supreme Court, they can also seek to remain free pending that appeal or that Supreme Court decision. But it is in the very rare case that an individual defendant is actually allowed to remain free pending appeal if they have been sentenced to a term of imprisonment.
Yeah. And Judge Moro, do you think the U.S. system better? So, should defendants be forced to serve jail time while their appeals are pending before the second instance court?
Well, recently our Supreme Court affirmed this new rule that after a conviction by the appeal court, the defendant, the convicted, should start serving the prison sentence. I think this was a kind of revolution in the enforcement of the law in Brazil, especially for complex crimes, not only bribery, not only money laundering, but even crimes committed by powerful defendants. So this would be another big step, and I think first we have to establish this new rule at once in Brazil, with no possibility to retreats, and we should not start talking about other advances at this moment. But I think in Brazil it would be important to defend this kind of rule for trials by jury. Okay, especially because the jury is not only the professional judge who give the verdict or the sentence, but the jury. And in our constitution, we have that provisions about the jury. And it's very strange when you saw in Brazil someone being convicted by a jury trial, and sometimes for terrible crimes. Anyway, the person went free out of the court. So maybe we could think about something like that, like U.S. system for jury trials in Brazil, and for the rest of the cases by now work to avoid any kind of retreat about this new rule of our Supreme Court.
Mrs. Das, and turn to you, rather different take on the question of companies and executives penalized or imprisoned for corruption crimes. More than 8,000 business participants, including various Fortune 500 companies, are participants of the UN Global Compact, and as such commit to its principle against corruption, amongst others. When a company you engage with is guilty of corruption issues, how do you deal with the situation broadly? How do you prevent these companies from blue-washing their activities when they engage with the United Nations to counter corruption on the one hand, and then go on to violate these commitments as evident from the huge corruption scandals? You have a strong local presence in Brazil as well. Would you have any instances from there?
Yeah, sure. So it turns out that both Petrobras and Odebrecht were participants of UN Global Compact, both at the national and local level. And, I managed the anti-corruption working group, which is basically from amongst those sort of 8,000 business participants, the more committed ones who want to participate in this platform of peer learning and sharing and exchange ideas. Petrobras was also a participant of that working group. So you see there was not a lack of good compliance practices or state-of-the-art policies in place. Everything was there, and the Brazilian anti-corruption law is also very strong. But the corruption scandal broke out. Now, so two things. Ours is a very inclusive approach, because if we try to exclude every company from engaging with us which has had a corruption issue, then perhaps we would have no participant left. I mean, it's a reality. And the idea of an inclusive approach is that, again, if there's a scandal, if there's a problem, that's great, because then there is an opportunity for improvement. There's an opportunity for dialogue and learning. Because if everything was perfect, we wouldn't need the UN or UN Global Compact, really. So I would like to work myself out of a job. Hopefully in my lifetime I would be able to do it. But so taking example from the Petrobras case, we don't have any police powers as a UN organization. So obviously we do not investigate or prosecute. Also we do not adjudicate. So if there is, a scandal happening and there's a lot of media report, we do not kind of presume that the company or the executive in question is guilty. We let the courts of law to decide that. But whenever there is an egregious violation of our principles, including, the corruption principle, anti-corruption principle, we have to take steps, because companies cannot just commit to our principles on one hand and then not show those commitment in action, in practice. And then what do? So in the Petrobras case, we first initiated something called the dialogue facilitation process. So our local chapter reached out to us. They had been receiving a lot of complaints from civil society organizations, even citizens, that Petrobras was allowed to be being a participant of Global Compact, kind of advertising it on their website and so on and so forth. But where is really the action? So when we got the complaint, we asked the question to Petrobras officials. Now it's up to the company to respond. If they do, then we start the dialogue process. If they don't, then we kind of brand them as non-communicating, which means that they fall into a category whereby when we don't hear from them in a certain period of time, then we can call them an inactive company and delist them. We had a very high-level conversation. Our then executive director had a conversation with the C-suite members of Petrobras. We asked them what the problem was. And the idea was not for them to admit anything. The idea was for them to commit that some things are happening. The courts are looking into it. What are they doing in action to put their house in order? Do they have a compliance committee in place? Does the board have enough independent directors who can point out to various issues? So basically, what are they doing now as a response to the issue? And we heard them out. It was encouraging that they understand there is a problem. There was no outright denial or anything. It also made tricky that it was a state-owned enterprise. So, it had that whole dual role of being a company, but at the same time, sort of being perceived as a public sector entity. And then out of, we after the conversation, we decided that till the time Petrobras is able to not only demonstrate commitment, but also respond and take actions. And while things are pending in the court, they will be delisted. So they would not be members of Global Compact, but at the same time, try to imbibe those principles within their operations and do their best. And at a later date, when things start looking positive and we see that, okay, things are changing. Our local chapter gives us a green light because, they are more familiar with the situation. We can take them back into the fold. And a similar thing happened with Odebrecht. And it's not just, companies from developing countries. I mean, in the Volkswagen case also, we issued a public statement that it's very unfortunate that Volkswagen actions or corrupt acts are actually, endangering human life and the environment. And therefore, since they have egregiously violated our principles, we will delist them. So while we encourage companies to engage with us and join us, if needed, we take strict action so that they don't blue wash their activities or just add the UN logo to their name. And secondly, I think it's important that we behave as guard dogs or, guide dogs. We call ourselves guide dogs. We try to guide people to the right path. We're not watchdogs who keep an eye out and then, suddenly pounce on you and put you in the prison. That's not our job. But be inclusionary, but don't let companies exploit the whole collaborative process. And if they do, be forthright and be bold and, take an action that you cannot engage with us anymore. And naming and shaming helps. I think that, there are legal risks and you can hire, amazing lawyers, one sitting right next to me, to, get your defense in place or even, get your prosecution in place. And you can put many legal arguments. But the effect of naming and shaming goes a long way. The reputational risks, I've get the opportunity to talk to a lot of young people. And increasingly they say that graduates from here, they have an option. They would not want to work for a company, perhaps, which has not only had a corruption scandal, but didn't respond to correct anything. So the whole employee morale, reputational risk, the fact that your peers, would not perhaps want to collaborate with you when you walk into a symposium like this, you don't have answers to what you are doing. And one last example is that of Siemens, which had a huge corruption scandal, and some of it had its effects in Latin America as well, and I think some cases are still going on in Argentina and so on. And they accepted that they had a problem. They had there was no tone from the top, and because they thought that paying bribes was business as usual, it was part of the system, they just went with the flow, and they bribed public officials in various countries. And then the World Bank kind of blacklisted them, so Siemens could not bid for any World Bank-related project, the UN blacklisted it from its procurement operations, and of course the prosecution going on everywhere. They kind of did a 180-degree turnaround, and they made a public, so first they accepted the issue was there, and then they made a public commitment to put their house in order. There was a settlement with the World Bank, with the EBRD, and as part of the settlement, they also agreed to fund local civil society initiatives on anti-corruption. So it was like a very interesting settlement where obviously prosecution is happening, fines were imposed, disgorgement of, the stolen assets and illicit assets happen. And at the same time, they decided that they want to change their behavior and they want to support local efforts. So they went ahead and put together this integrity initiative. So you see that there are examples of companies that have done that 180-degree change and are committed to transforming. So we hope that through our continuous engagement, companies in Brazil, including Petrobras, etc., would be able to come back to a fold. And then we brought them back, like Siemens became a Global Compact participant again after like a gap of 4 or 5 years. So I'm very hopeful that things are going to change.
Okay, let's now talk about plea bargaining, which has long been a core feature of the American criminal justice system. As of 2013, 97% of all the criminal charges in the United States were resolved through plea bargains. The impressive guilty plea rate may be partly attributed to the existence of the so-called sentencing guidelines, introduced at the federal level by the Sentencing Reform Act of 1984 and adopted by many states as well. These guidelines, along with mandatory minimum sentences, equip prosecutors to induce defendants to readily accept the offer of a reduced charge, which entails a milder punishment. In contrast, the practice of plea bargaining is frowned upon in other countries, where it is viewed as a way for guilty criminals to escape the full responsibility for their acts. Mrs. Kestenbaum, what are the pros and the cons of the American system?
So, as you note, Professor Bodart, Judge Bodart, in this country we have a very, very high percentage of criminal cases that get resolved by plea bargains, and individual defendants or even corporate defendants do not actually go to trial, though it is their right to do so. Analogously, in the civil system, the system of civil litigation, the vast majority of cases settle and do not go to trial. And the main advantages for really everyone, and especially for the system, is efficiency, of course. We have such a high rate of both criminal and civil litigation in this country that if every single party were to go to trial, I mean, it would break our system, and we would just have much less enforcement of the criminal laws in that situation. As you know, other countries don't have the same high levels of guilty pleas and plea bargaining, and there may be a perception that defendants are getting off easy because they are pleading guilty to lesser crimes than they could be charged with. I think the irony is that actually, for the most part, the opposite can happen. And so, especially, and I think there are inequalities that are created in our system between indigent defendants, which of course are most defendants, and defendants who have the means and opportunity to fight charges. That's because the government has an enormous amount of discretion and power in deciding what crimes to charge a defendant with. And so the system, the laws that you describe, like mandatory minimum sentences and the sentencing guidelines, I think actually what you see there is it gives prosecutors an enormous amount of power and discretion because they can threaten, and I don't mean in a bad way, but just they can make decisions about which crimes to charge a defendant with, even for the same set of facts, the same course of conduct. And so what you can see is that sometimes defendants will accept a plea bargain to avoid the risks of a mandatory minimum sentence, for example, even if the weight of the evidence is not that strong. And a very prominent judge in this country, Judge Rakoff, wrote about this and has spoken about this. So in 2014, he wrote an article in the New York Review of Books called Why Innocent People Plead Guilty. And he talked about exactly this phenomenon, which is the phenomenon of defendants taking plea bargains because of the fear that's being held over them of mandatory minimum sentences. Now that goes for the most part, as I said, for indigent defendants. I think that we have a somewhat unequal system because you don't see that same thing happen with white-collar defendants who often have the means to fight and won't necessarily will put the government to their proof. And so I actually think that you create somewhat inequalities in our system between most crime, which is not white-collar crime, it's sort of street crime, and people under pressure from the prosecutors to plead guilty. And our bail system also weighs into that because although, as I said, the law is supposed to be that bail is, that you are released on bail if you are not yet been convicted, often indigent defendants can't make bail, and so they are incarcerated, and they decide to plead guilty so that they can end that incarceration as soon as possible. And again, you don't see that often with white-collar defendants. So I actually think that our plea bargaining system in this country can actually sometimes result in people facing, greater punishment than they might if they went to trial. Now that's different. I'm talking here about what I call straight pleas, not cooperation. A lot of when you see defendants getting lenient sentences, it's because they've cooperated with the government and they've made the decision that it's worth it to cooperate, and the government has made the decision that it's worth it to offer either leniency or the chance of leniency in order to have a witness or witnesses who participated in the crime and can help them build a case against others.
In Brazil, where the rules governing plea bargaining are very vague, the public opinion has harshly criticized some of the agreements between the prosecutors and the defense counsels of people implicated in corruption schemes for being too lenient, considering the seriousness of the accusations. Curiously, some politicians complain about testimonies obtained after pretrial arrests because they think the defendant is being forced to blow the whistle in order to get out of jail. Some reform proposals currently under discussion in Brazil include setting a minimum jail sentence for guilty pleas and forbidding plea bargaining with imprisoned defendants. Judge Moro, do you support any of these proposals? What is your take on the severity of plea agreements in Brazil?
It's important to say that this discussion in Brazil is totally different than the discussion here in United States, because you are talking about your concerns about street crimes and this system being harmful to indigent defendants especially. But this discussion in Brazil is being made especially in cases involving white-collar crimes and bribery, and now we're talking about usually powerful defendants with the most expensive lawyers of the country. Corruption usually is a crime committed in secret, involves who pay the bribes and who took the bribes, who take the bribes. So sometimes you need to make a deal with one of these criminals to get evidence against other. Not always, but sometimes you need that. I think we are improving our practice in Brazil. In certain way, this is very new. And I agree that maybe some of these agreements should be harder against the defendants who made it. But you have to consider the conditions of the negotiation that the prosecutors have. And when you saw that you have a past of impunity, you have some uncertainty about the future, for example, about this rule over the enforcement of the conviction after a decision of the appeal court. Sometimes the defendants, they believe that maybe the best choice is to make a bet on the impunity. And sometimes it's difficult to the prosecutors to discuss hard agreements or hard conditions in these agreements. And sometimes you have some agreements that are too soft, I think. But about these proposals, I think the most part of it does not make sense. You could not forbid a defendant in prison to make a plea agreement, because it would affect his defense rights. There is no reason to make a distinction between a defendant who is in prison and the other who is not. And I saw sometimes in this car wash operation, there is a critic that, for example, pretrial detention is being used to get agreements, but it's totally untrue. The most part of the agreements were made with defendants who were answering the charges without any kind of restriction. So for me, it does not make sense. And the other one proposal? The other proposal?
Well, there's a proposal to set a minimum jail sentence for guilty pleas. So
I think it depends on the case, and it's sometimes difficult to defend this position when you have a system with still, despite of the recent progress, a system when impunity is a great possibility. Sometimes you don't have, I think, the prosecutors made these deals, these agreements. Sometimes I think they don't have enough tools to look for hard agreements for these defendants.
Mrs. Das, from an international conventions and policy perspective, is there support for provisions like plea bargaining, which in effect lower the bar for corporate accountability for corruption-related crimes?
Yes, there is. So it's very well recognized in international criminal law. So UN Convention Against Corruption in its Article 37, it recognizes plea agreements, and so much so it goes a step ahead. It also recognizes cooperation agreements or exchange, impunity in exchange of critical information if there is a corruption issue. If you look at the example of international criminal law, the crimes against humanity, genocide, so the Rome Statute of the International Criminal Court, and then procedures governing trials and witness examination at the International Criminal Tribunal for former Yugoslavia and Rwanda. So basically all these, courts or tribunals that deal with really heinous crimes also recognize plea agreements or guilty pleas. So they are part of international law, and they are here to stay. And it's obviously very prevalent in the US, but many countries are catching up, and their merits are definitely there. Expediency, reducing the burden on the judiciary, and also effectively using the already under-resourced, the prosecutorial process. So yes, they are here to stay. But even when in the international conventions and the jurisprudence that has developed in some of those serious cases too, there's always been this idea that there should be checks and balances and judicial oversight whenever there is a situation like this, because there is a possibility that the negative effects can outweigh the merits of plea agreements or plea bargaining. And I think I was reading somewhere that even in the Lava Jato case, some of these plea agreements led to unearthing of some critical information that led to further prosecution and investigation. So they have their merits. So what do we do? Many civil society organizations like Corruption Watch and Transparency International, they have said that you have to look at the case. So if the person being prosecuted is, say, one of the highest executives of the company, or a person holding really high office, the gravity or the moral gravity of their conduct is very severe. So a plea agreement should reflect that, because there is a risk that it can be perceived as impunity or lowering the bar of corporate accountability, or even public officials' accountability. So when we did the review mechanism for the UN Convention Against Corruption, actually Transparency International gave us a set of recommendations on this Article 37, how we could make it more robust. And they said that, some of the things when these plea agreements are being incorporated in a case like that, you have to see basically that any of this agreement should not come without the admission of guilt. Now, there could be merits to that argument, and you can argue it both ways. But in high-profile cases, an admission of guilt should be there, so that the person or the executive or the official does not just escape, without any kind of accountability in there. Secondly, they also say that whatever the plea agreement is, it should be published and disclosed to the public, because corruption is not a victimless crime. We say that the citizens, the people, are its biggest victims, so they need to know what is the plea agreement or plea bargain that has happened, or impunity agreement that has happened. And there are many other things like compensation to victims. You have the sanctions should be strong enough. So an agreement does not mean that the company should not be sanctioned enough. And judicial oversight is really important. So they are a part of international jurisprudence. They are here to stay. But checks and balances are important, because as you rightly mentioned, the risk of them being misused to let people go scot-free is really high. Yeah.
So now let's talk about another question that was also brought before the Supreme Courts of both countries, that has to do with the funding of electoral campaigns. The Supreme Court of the United States in Citizens United decided that the First Amendment protects independent expenditures in elections. In McCutcheon, the court also struck down caps on electoral contributions from individuals. And the Brazilian Supreme Court in 2015 ruled unconstitutional a statute that authorized corporations to make donations to electoral campaigns. Many analysts believe that the prohibition can be easily circumvented, which will result in a less transparent political process. Judge Moro, do you agree with this criticism? And how can we prevent the electoral system from being turned into a big laundry for dirty money?
Maybe it was already before this decision of our Supreme Court. I think this was a great decision by Brazilian Supreme Court. It forbid electoral contribution from companies. The problem was that the law at that time was too permissive about electoral contributions from companies. Like, for example, a company could obtain a public contract from the government, a billionaire contract, and just after that, the company could make large donations for the party who was in the power of this specific branch of the government. So this kind of situation favors improper relations between the public and the private sphere. And faced with a very permissive law, our Supreme Court decided that it was void. I'm not sure if the Brazilian Supreme Court forbid at all electoral contributions for companies. Maybe if the Congress approve new law about it with proper regulations and proper limits, maybe it could pass in the constitutionality test before our Supreme Court. Of course, when you forbid all kind of company contributions and you don't have a tradition of individual contribution for elections, you will have the problem of fraud. Well, that's something very new, and we will face for the first time a general elections here in Brazil since this rule of our Supreme Court, and let's see how the system will work. But the fraud was there even before, for example, based on cases already tried in Lava Jato operation, there are cases that bribes were paid in the form of electoral contributions, and sometimes with a very specific level of quid pro quo that we talked before.
And Mrs. Das, do international legal conventions and public policy have a position on campaign financing and the corruption risks associated with it? International and national civil society organizations have critiqued this on various grounds. What is your take on this?
So let's see, from a policy perspective, there's this leading international civil society organization that does these surveys, and this particular one is called Corruption Barometer. And police was recognized by most of the respondents in various countries as one of the most corrupt public institutions. Can you guess which one was a very close second? Anybody has an idea? Elected representatives. So police and politicians, and they were tied, not just very close, they were tied for the first rank, and followed very closely with government officials and then business executives. So they had them all covered. So yes, so there is definitely a risk Now, when you talk about international convention, the UN Convention Against Corruption, in its Article 7.4, it basically calls upon member states that have ratified the convention to enact domestic laws that advance transparency in disclosing campaign financing and political, donations to political parties. So basically, which means that this is part of the system. It would not go away. But the idea is that there is a corruption risk associated with it, very eloquently highlighted by, by the panelist. And so what should we do? So the member states are called upon to enact laws. And 88% of countries have some form of law or regulation either asking for disclosure of, such financing or donations made to political parties or candidates. So there's a very interesting website run by this Institute for Democracy and Electoral Assistance, IDEA, and they maintain this whole website where you find a lot of information on, what are regulations in which countries, what they disclose, what they don't. So if anybody is interested, should go check it out. But only 53% of those countries actually require both. So there's a loophole right there. So what is going to the candidates and what is going to the political parties? It's sometimes separate, and it's not both counted as campaign financing. And secondly, some disclosures are made, but then they're not accurate. And, there are abundant number of laws, but obviously enforcement always is a problem. So there has been this whole policy, advocacy, public opinion building that when these disclosures in both cases to a candidate or to a party should happen and should be published. And in countries where there is right to information or, laws related to access to information, there are some checks and balances. A normal citizen can go and ask for what really was donated to a particular party during a campaign. But civil society organizations are basically saying that there should be independent verification of that disclosure, because you see that, even candidates, when they disclose their own assets, it's really not accurate. Because, we can talk about it the whole day, but basically, beneficial ownership, ultimately, who holds which assets, and some people are just for namesake. All those things happen, and there's no independent verification. So, from an international legal perspective, countries are required to enact those laws. Are those laws there? In most cases, yes. There are loopholes in those laws. Enforcement is a challenge. So what do we do now? Well, yes, independent verification of the disclosure could be one thing. The other, the idea, and some of them that when you send the briefing note across was also that the state could match some of those fundings. There could be a ceiling on the amount that a business or an individual can donate to a political party. But if there is no real commitment and the electoral process is independent of the executive, till that happens, it's going to be an issue. So in many countries, election commission is sort of considered independent, but it's at the end of the day a political appointee. So the state always has the risk, there's a risk that the state can abuse the whole process to its advantage and use the state funds to benefit its own campaign. So I think the citizens, but they are sort of waking up to this problem. I see on social media whenever there's an election happening, young people, and with the boom in information technology, they're able to share information so quickly, and they're able to sort of tweet and ask their senators and congressmen and people the right kind of questions. So the questions are coming out. Well, we'll see how much answer they receive, but the questions are definitely coming out.
Okay, now I want to focus on an issue that is frequently regarded as a stumbling block to the punishment of politicians involved in white-collar crimes. The Constitution of Brazil grants privileged legal standing to congressmen, senators, and top-level officials of the executive branch of the government, among others. These persons, who total about 55,000 public agents, cannot be prosecuted in conventional courts. Instead, their investigation and trial must occur before higher courts, including the Supreme Court. Some might feel that this framework facilitates political interference and allows for the evasion of proper justice due to the statute of limitations. Judge Moro, should an amendment be in store for the future of the Brazilian Constitution?
Oh, I totally agree. Of course, the Supreme Court is deciding a case that could restrict this privilege, but I think they will decide in the right way. It seems that there is already a majority. The final judgment is pending, but of course there are limits about what you could do with interpretation of the Constitution. So what is needed in Brazil is a constitutional amendment to finish with this kind of privilege. The problem is that our superior courts, they have a heavy caseload, and in practice they could not try these cases in a reasonable time. So this privilege usually work as a kind of shield against effective accountability. And I think if you think about democracy in a large picture, you have there liberty, equality, integrity, and everybody have to be treated. Everybody deserves the equal protection of the law. Usually think about this issue about the vulnerable people who need the protection of the law, but there is other way to think this principle, and it's important that everyone, no matter how powerful this person is, should be accountable before the law. And this privilege works against this kind of accountability. I'm totally in favor of a constitutional amendment to finish this kind of privilege, even for judges. I don't think it's necessary even for judges.
Mrs. Kestenbaum, do you believe that statutes of limitations play a significant role with regard to the punishment of white-collar crimes in the United States?
So statutes of limitations can play a significant role in any particular case if the conduct occurred a long time ago. But for the most part, in the majority of matters, including white-collar matters, I actually don't think that they do so. The statutes of limitations at the federal level for most white-collar crimes, including FCPA, is generally 5 years. There are some statute of limitations that are longer than 5 years, and there are some crimes that don't have statute of limitations. But the government can easily extend the period for which they can charge through a number of ways. I mean, first of all, most white-collar crime is not committed by just one person by themselves. They usually are committed in conspiracies, and conspiracies are considered a continuing offense, such that even if a particular person who's a part of the conspiracy ends their actions a while ago, unless they withdraw from the conspiracy, then the statute of limitations doesn't begin to run until the last co-conspirator takes the last act in furtherance of a conspiracy, and that act doesn't have to be itself illegal. It could be something that's otherwise innocent, but if it was taken in furtherance of the conspiracy. So that's one way in which the government can extend. There's other ways as well. So for example, in the anti-corruption area, this is a frequently used tool. If the government can show by only a preponderance of the evidence that it reasonably appears that there is relevant evidence in another country, which of course by definition under the FCPA that's almost always the case, then they can apply to a court to get a tolling of the statute of limitations for up to 3 years. So again, the 5-year statute of limitations can be extended to 8 years. And then often when companies and individuals are under investigation, the government will ask if they will be voluntarily willing to enter into tolling agreements. Individuals sometimes enter into them, but less likely. But companies, under pressure, sometimes will decide that it's in their interest to cooperate, or for other reasons to enter into a tolling agreement, tolling the statute of limitations. So that's another way in which the government can often extend statute of limitations. So this is just by way of saying, I think it's the rare case, unless it's very old conduct, in which case it may be lost to the statute of limitations. But more often than not, the government can often find ways to bring charges.
We're running out of time here, but I think we have still time for a last question, especially for Judge Moro, about the problem of political pardons, which is a problem that has recently become the subject of much discussion in different parts of the world. For example, in South Korea, 5 former presidents were accused or convicted for taking part in corruption schemes involving the country's big conglomerates. However, presidential pardons have benefited corporate leaders who were imposed prison sentences, such as the CEOs of Hyundai and Samsung. And in the United States, some commentators have suggested that President Trump can be charged with obstruction of justice for using the pardon power to protect himself and his allies during the investigation into Russian interference in the elections. And in Brazil, the current president has issued a very controversial blanket pardon, which might benefit those closest to him and possibly himself. So do you think that the criminal justice system in Brazil is vulnerable to political interference? Particularly, should the pardon power be subject to limits?
There's an open case before our Supreme Court about this presidential pardon. It's interesting to say that the practice are different from one country to another. It seems that, for example, in Korea or United States, the presidential pardon is directly to specific individuals. And in Brazil, it's quite different. I remember reading a long time ago about individual pardon gave by Peter II, the Emperor of Brazil, for a man who was convicted for a death penalty, but that happens, wow, a long time ago. Nowadays, usually the government, I'm not saying this government, this actual government, but even the past government and the others before, they usually made this general presidential pardon to anyone who fulfill the conditions of these pardons. Usually when you are serving prison sentence and when you already have served a large part of it. But in time, I think these presidential pardons become more and more generous. And there is some controversy about this last one because it was very generous. If you, for example, served a small part of your sentence, you would be benefit by this presidential pardon. I think there is some indeterminacy on it, but I think there is some limits on this presidential pardon. And about this individual presidential pardon, that's something that it's a little bit strange for our recent practice in Brazil. Maybe sometimes general pardons could also be targeted to specific individuals, but that's a different issue.
I think that most of the questions that the audience sent here were more or less covered by the topics that we have explored here. And then I'd like to ask if any of the participants have questions for the other sitting members. If not, I hope we have progressed here the understanding of white-collar crimes on a global scale, and we can work together to eliminate it. I would like to have a round of applause for the sitting panelists for taking the time to participate in this panel. And we have the certificates here for the speakers.
I learned a lot from you. I have known. Thank you. Oh, thank you.
Our honor.
Thank you very much.
Thank you very much.
Thank you.
Yes.